Assalamu alaikum rahmatullahi wa barakatuh. Welcome back to Legal Ease, the show that converts legal jargon into legal ease. I must say, over the past weekend, I was inundated with comments whilst I was attending a function about the amount of support that we get from for Legal Ease and the amount of people that actually watch it. And I'm very glad to say that the show is actually doing what it set out to what it was its initial aim and what it set out to do, in that it actually is educating the layman and the person in the street. And tonight, inshallah, we aim to do that once again. Tonight we're talking spies, bugs and worms, how cyber law is regulated in South Africa. And to help us to do that tonight is a man who shares a name within the same species of what we're talking about, although he is far from slow. His name is Sizwe Snell, and he is an expert in cyber law and information technology law. Mr. Snell was born in Germany. He went to school at Pretoria Boys High, and he obtained an LLB degree at the University of Pretoria, where he took a special interest in cyber law and information technology, and is now completing his LLM in information technology law. So let's talk to the ever-fast and up-and-coming Mr. Snell. Assalamu alaikum, good evening, Sizwe. Thank you so much for joining us.
Hi, how are you?
Good, thank you. I am going to say your surname a lot because I do find it very interesting. And I'm telling you that if I couldn't forget it, I'm sure people sitting at home won't forget it. So
that's a very catchy surname.
It is indeed. Spies, bugs and worms, cyber law in South Africa, something that you do on a daily basis. Before we get into that, how did you start cyber law? An introduction into yourself, and what do you do on a daily basis?
Thank you. Well, cyber law as a practitioner is basically assisting clients with legal matters pertaining to ICT law, pertaining to e-commerce, cybercrime related issues, anything within the space of ICT communication and disputes that may arise as a result of that.
ICT?
Information Communication Technology Law.
Right, okay. So when you talk about information communication technology, you're saying basically the passing of information through any electronic media or means.
Basically, all the communications that we do via Facebook, via emails, even via phones and via your tablets.
Right.
Everything that happens within that cyberspace, within that realm, within the cloud, as they like to say.
Yeah. So look, you're not just a director and founder of Snell at Law Attorneys, but you also do a little bit of something else. You're also an academic in that you're completing your master's. Talk to us very briefly about what that's on, and then you do something called Lex Informatica, which is a conference. It's an annual conference. Talk to us very quickly about what that is, if you can.
Okay, my master's thesis concentrates on electronic contracts.
Right.
When is an electronic contract concluded? Where is it concluded? If and when, how was it concluded? All these aspects that the law usually had controlled or regulated in the common law. The Electronic Communications Transactions Act now has regulated that. We've also now heard that there's the new African Union Cybersecurity Convention, right, which has now also become law. So these are the sources of law that we use in terms of interpreting electronic contracts. There's several international instruments as well,
okay,
but I don't think we should bother the listeners or the viewers, should I say, with all of that.
Lex Informatica, it's a conference?
Lex Informatica started as a conference in 2007, a workshop as well. We've now extended the Lex Informatica as a full-blown consultancy. Mm-hmm. You can find us on lex-informatica.org.
All right.
There's a consulting element now of Snell Attorneys, where we help with legislative drafting, policies. With regards to ICT, we do training all over Africa, East Africa, Central Africa. Recently now also I was in Ghana. Mm-hmm. So we do a lot of training, a lot of education, a lot of assisting of African states with regards to their implementation of laws regulating the cyberspace.
Well, you'd be interested to know then that this show goes live to various countries in East Africa, to a number of viewers. So that's quite good for your clients if you have any there.
Yeah, surely.
Certainly. One thing that you mentioned, which is quite interesting for me, you talked about e-contracts. Let's just start with that very quickly, all right? We've jumped the gun. We haven't even discussed what cyber law actually is.
Sure.
But we'll get back to that. What I want to ask you is, we've moved away. It was in the past very difficult to prove a blood contract, and then now even sometimes an ink contract. How do you prove something that's neither bloodied or signed?
Well, the ECT, the Electronic Communications Transactions Act, has made these things easier now. We now have what we call a functional equivalent approach. Everything that you can do in handwriting or in the real space,
right,
the functional equivalent thereof can be now done in electronic space. So, for instance, the ECT says where the law requires something to be in writing, it will not necessarily be without legal effect because it's in data form. The fact that it's in data means that it is still in writing.
All right.
All right. Section 13 of the ECT talks about signatures, all right, electronic signatures. We have 3 signature regimes there. We have what we call an advanced electronic signature. That is where you have to have your electronic signature regulated by the accreditation authority. There's 2 accredited companies right now. It's the Post Office as well as Law Trust.
Right.
They give out electronic signatures for these advanced electronic signatures. Then you have an electronic signature in the normal sense, like the one that you have on your email address,
right,
right at the end, where you physically scanned in your signature,
right,
and you've appended it, right, to your email.
So is that now set? Is that sufficient for purposes of evidentiary proof in a matter, for example?
In terms of admissibility, any electronic document is now admissible in court. So yes, that would be admissible. But you would probably have issues as to who put that electronic signature there, or the scanned copy of your signed signature. That's some of the issues that one may question. And then we have a third type of electronic signature, and that is the one that we do every day and we're not even aware of. Every time when you log into your online banking, when you click I accept on Kalahari,
yes,
when you click on Amazon and you say I accept, then you are signing by way of conduct.
But aren't you, all you're doing there really is you're saying, I've read and understand the terms of the above agreement, even though I have never read nor understood the terms of any document that I've read on the internet. But you're saying that you read and understood it, and that you've now entered into a binding agreement. Is that really
binding? Basically, as I'm saying, the fact that it's in electronic form doesn't change it. The only agreements that you cannot conclude electronically in terms of our law in South Africa are 4 transactions. You cannot have an electronic will. You cannot have an electronic check or bill of exchange.
Right.
You cannot sell a house. In other words, that deed of sale cannot be in an email. It still needs to be written, it still needs to be signed.
Right.
And lastly, you cannot enter into a long-term lease longer than 20 years. In other words, if you have a long-term lease that is 19 years and 364 days, then that lease is valid.
If done electronically.
If done electronically.
Okay, I mean, I wouldn't even want to, at this stage, delve into why they would have done that. But I mean, I suppose the legal drafters such as yourself one day probably have good enough reasons. In a nutshell then, what are we saying cyber law actually is?
Well, cyber law is nothing new. I always tell people that cyber law is a hybrid law. It's a multidisciplinary law.
Right.
It encompasses all the laws that have been there BC, before the computer, and AC, after the computer.
Right.
So that is cyber law, regulating the electronic space with reference to the law as it was, catching up with the technological developments and being in line with that. I think that's what cyber law is. Okay,
well, that's, I mean, you know, I don't know that we understand cyber law in this country, although having said that, we are relatively advanced in respect of where we've come from in our democracy, so to speak, and where we are now. I think we're quite advanced from electronic communication, from a technological perspective.
Well, yeah, I think the laws are there. They're in place. We have the ECT Act, the Electronic Communications Transactions Act. We have RICA, the Regulation on Interception and Monitoring of Communication. We now have also POPI, the Protection of Personal Information Act.
Correct.
And we have also the CPA, the Consumer Protection Act, which regulates as to how you as a consumer can enter into agreements with an online seller, or an e-vendor as we call them.
So all those essentially find a home within cyber law?
Yes, like I said, the body of cyber law encompasses all these different legislations,
Yes.
all these different cases. Right. If you were to say to me, where do I find a body of cyber law? I would basically say, well, it's in the legislation, it's in the cases.
Right.
There are one or two textbooks that are out there as well. We've also drafted one. It's called Cyber Law at
Yes,
SA.
so talking about that, that is actually a textbook that you authored,
That's
co-authored.
correct. Yes, we edited that, and I wrote one or two chapters in the book as well.
What is it called again?
It's called Cyber Law at SA3.
Cyber Law at SA3.
Yes,
and
it's the third edition.
On the net?
It's available on the net.
Cyberspace, so to speak.
You can have a e-version of it,
Right.
or you can go down to an online bookshop or your physical bookshop, and you can buy a copy of that. That can give you an idea as to the body of cyber law, the areas that we cover. But as we said, cyber law changes every day. Every day that a new scientist comes up with a new technology, the law has to come up with a new solution for a new problem.
Mr. Snell and his firm can be found on the internet. This thing that we're discussing today, this beast that has come upon this world, can be found on the internet at snellattorneys.com. His details also appear on the screen, but also, very importantly, get into it, go and take a look at the publications that he's put on on his website, what they do and what they're about, and we'll soon find out that, in fact, all attorneys need to do some homework in respect of cyber law, because quite honestly, it is going to come a time where people are not going to print, people are not going to send letters, contracts are not going to be in writing and in hard copy, and we're all going to have to know how to deal with it.
Yes, as a coincidence, I'm actually on the e-law committee of the Law Society.
Right.
And we have taken numerous endeavors. The one is the e-signature pilot project taking place now in Natal. We've also done several trainings around the country, Durban, Cape Town, Bloemfontein, where we go out there and we educate practitioners about these laws and how they impact on their practice and their clients.
Very, very, very interesting, and something that, as I said, and I said it before, we really need to all learn a bit more about. You know, we're in our mid-30s, our early 30s, sorry. Don't let our looks deceive you. We're in our early 30s, and we really need to keep up with the times, really speaking.
No, definitely.
So please keep me a seat on that conference. I'm definitely wanting to come and learn a lot more. And for all the lawyers who watch the show, and I know that there are a few because we've taken a lot of calls from a lot of lawyers on the show, make sure that you also dial into snellattorneys.com and find out a bit more of what they offer from an educational point of view. I think we all need to get educated on this. Whilst you guys are pondering that and hopefully taking out your iPads and logging on to snellattorneys.com, we're going to take a quick commercial break and satisfy our sponsor. When we come back, we will start talking spies, bugs, and worms, how interception is done within cyber law and cyberspace. Thank you so much for staying with us. Jazakallah. Assalamu alaikum.
Whether it's style, elegance, or just plain casual, at IBO we provide you with only the best international clothing brands at the best prices. We stock everything from pants to shirts and footwear at the best prices. Come in today for a great shopping experience with an even greater customer service. IBO International Brands Outlet.
SA's leading bathroom design store, offering exclusive products and the world's leading brands in sanitary ware, taps, tiles, and bathroom fittings. Why settle for less when you can have the best? We offer value for every budget. Visit our exclusive showrooms to experience why we are different. Exclusive brands, customer service, variety, value, and backup support. Classic trading, luxury bathrooms.
Welcome to Dada's Motorland. South Africa's premier used exotic sports car dealership. We stock only the best from BMW, Mercedes-Benz, Porsche, Ferrari, Lamborghini, Aston Martin, Maserati, and much, much more. So if you have the need for speed, come into one of our branches and select the vehicle of your choice. With dedicated staff to ensure your satisfaction, there's no better place to get the wheels of your dreams. Dada's Motorland.
Throughout history, there have been many champions of flavor and taste, but Jimmy's still reigns supreme. Our Killer Grill's menu boasts the sauciest steaks, spicy and tender chicken dishes, beef burgers. We are leaders in explosive and flavorful taste experiences, resulting in amazing journeys of delight. Try us for our superior taste, adding excitement and zest to your life. New restaurants open countrywide. Jimmy's Killer Grills, the addictive taste.
Assalamu alaikum, welcome back to Legal Ease, the show that converts legal jargon into legal ease. We are talking to Sizwe Snell, and despite his name, he is an extremely quick thinking and quick talking attorney who is now specialized in cyber law and information technology law. So we turn once again to Sizwe Snell, and we continue our discussion as we were having it. If you just joined us, we're talking spies, bugs and worms, how cyber law is regulated in South Africa and what actually cyber law is. So Sizwe, we were just talking just before the break, we were saying that we're going to get into interception. Something that has really been placing itself within the common law, divorces, contracts, as you mentioned already earlier, criminal matters, interception of information. You mentioned Poppy. It's a little bit difficult because somebody of your intellect who is so knowledgeable of the thing to give a layman explanation of it. But what is interception? And are we talking just of communication or of information as well? Is it legal and are there penalties? So if you can talk to us on that.
Sure. I think maybe we should start at the beginning. There was the Interception and Monitoring Act that was brought in 1992. And the reason why that was brought was to change the old Post Office Act that had allowed the old apartheid regime to intercept your mail and to intercept your phone as much as they pleased like it because of their own reasons at that stage. So the interception, or the prohibition of Interception and Monitoring Act was specifically brought there to outlaw unlawful interception.
Okay.
In other words, if you're not a party to a communication, then you can't record the communication and you can't intercept the communication because you're not a party to it.
But does it mean you're not able to or you're not allowed to?
Well,
this is the question of that, is Big Brother really still watching and can they intercept?
Well, the ability to intercept is there. As long as you have a computer and the know-how, you can intercept. I can intercept you right here on your tablet right now. I can make your tablet do things. I can listen to your conversations through your tablet. I can do all sorts of things with any smart device.
And this is all over the internet protocol?
Yes, you can do this over the internet. I mean, that is how some of the people get your passwords with keyloggers. Keyloggers are the things that actually register your keystrokes when you're putting in your passwords. And then someone else is sitting on the other side of the world recording your keystrokes and monitoring that. Even your camera on your laptop. Some people even prefer to close that camera if it's not operative, because someone can actually switch your camera on and off from a remote location without you knowing.
But what are they, okay, before I even ask you this question, let me just say now, the phone lines are going to be open, because when I tweeted on the show initially, we got a lot of questions about my ATM, my bank account has been hacked. What do I do? Somebody has done keylogging, so I've typed in my password and they'll be able to take my password.
Sure.
Let's open the phone lines. There's a lot of people who are interested in wanting to know about this specific aspect. The phone lines, as you know, obviously, the number to dial, as you know, is 011-086 7700 or 1 or 2 or 3. Please call us. We will stand by to take your calls with regards to cyber law and what it means and how you can be helped if you have in fact a problem. Let's turn back, Sizwe. Sorry, you were saying?
Yes, so like I said, you know,
keylogging and those types of
keyloggers, phishing attacks, these are all methods in which your personal information can get out there for people to access your email accounts.
So what is phishing?
Phishing is nothing else but I think the reason why they put the H there is because it has something to do with fishing. You know, when you're fishing, you're going there to get something.
Yes.
But fishing is not necessarily like fishing.
Yes.
Fishing is where you are electronically fishing for other people's information.
Yeah. Yes.
So I think that is a layman's way of putting it.
Yes.
So once you illegally intercepting, you're not just in contravention of the RICA Act, but you're also in contravention of the ECT Act, which also specifies that you may not illegally intercept any communication in its occurrence unless there are certain circumstances, and those certain circumstances you will find in the RICA Act, where, for instance, law enforcement needs to investigate a particular matter. They will get an interception order from a judge.
It's Section 204, is it right?
It's like a Section 204, but the RICA Act has specifically put a procedure where they say that a designated judge must be given an affidavit showing that there's a prima facie case for whatever criminal activity that is being suspected. He can then give this interception order. You will recall the case of State versus Twele,
right?
Our former Safety and Security Minister of Security, the ex-wife. She was convicted on several criminal matters as a result of an interception order that was granted, and her telephone calls and SMSs were used successfully in the criminal prosecution.
So what is the penalty for this unlawful interception?
Well, as it is now, the penalties are not so stiff. I think you get a maximum of up to 3 years.
So there is a mandatory custodial jail term?
Yes, there are, but in terms of what we believe as an appropriate jail sentence, we believe the ECT is a bit relaxed. I think at the time in 2002, cybercrime wasn't such a big issue. So the sentences that the drafters had in mind were not necessarily, should I say, appropriate to the problem of cybercrime. But you will see now in the ECT amendment bill, stiffer crimes have been put there, stiffer fines, up to R1 million, sentences up to 10 years. So cyber criminality, illegal interception is a reality now, and you can go to jail for that.
So something as simple and as easy as hacking into a WhatsApp account, is there a penalty for that? Is that regarded as unlawful interception?
Yes. Well, it's not even illegal interception as such. It's literally hacking, as you call it.
Right.
There should be a difference between interception and hacking.
Okay.
Interception is where a communication is taking place, or where a particular conversation is taking place and you are monitoring that, or where there are emails being exchanged and you're monitoring that exchange of emails. Hacking, on the other hand, is where you are sitting at home with your computer and you are accessing illegally a database or a computer system that does not belong to you, that you're not authorized to, and you are sitting on that. In fact, the definition of access goes a step further. It also says that where you have access, but you know that the access is not actually granted. In other words, where you by mistake came over the access of someone else's bank account, and you become aware that you're actually not the user, but you stay on, then that access is also illegal.
Right. Well, as you hear, I mean, something that is really, really interesting, and something that's really commonplace in today's society. We all use social media. We all use electronic means. We're going to be talking a lot more about social media in a few seconds. The number to dial if you have any questions to ask us is 011-086-7700/1/2/3, and then it obviously appears at the bottom of the screen as always. Please call us and we will take your calls. Sizwe, social media. We've had a show on social media before, but now we're talking about social media in the cyberspace, which is where it really is stationed. Things like defamation, insults, bullying on text message or on WhatsApp or on Facebook, all these things, how are they regulated?
Well, up to not too long ago, there were no specific laws that regulated social media conduct.
Correct.
But luckily, we've had some litigations in the last couple of years where our courts have explicitly stated that certain conduct, or should I say unlawful conduct, whether it's in the physical world or in the cyber world, will not be accepted. For instance, we have a recent case here in Johannesburg and one in Natal recently, where ex-spouses were defaming each other on Facebook.
Right.
And as a result thereof, the one party obviously went to go see a lawyer. They wrote a letter of demand to remove the said postings. They refused. And the matter actually went to court. And the court actually ordered that particular person to remove those postings. As obviously Facebook is in America, so we can't send the sheriff there to physically remove it. But the party was actually ordered to remove it, failing which the court then said it should be advised so that it can take other steps with regards to the content of that order if it has not been carried out. So defaming people online, you can run into trouble, you can get a cost order, and you can have someone take you to court for that, and you can be ordered to remove that. Similar to defamation is also the aspect on social media pertaining to usage of social media.
Right.
Now, how do you use social media? One would say, once again, there are no rules, all right? But there are rules pertaining to what may be said on social media.
Right.
In other words, on the one hand, we had a party who simply asked that the comments be removed.
Right.
But in a recent case we had, which was decided in Pretoria, we actually had a party that actually sued for damages.
Yes.
For defamation online.
Yes.
And the court agreed. All the requirements for defamatory suit were satisfied, and the party was ordered to pay 30,000 rand as well as legal costs.
Interdicts. I'm involved in a matter now where we've just lodged an application for an interdict against someone who has severely defamed a company that she previously worked for. How was the court's view, and what is the level of evidentiary proof? Now remember, okay, well, I'll answer the question first, and I'm going to just follow that question up with the remembrance that when you're talking about the extent of the damage, if it's put on Facebook, I have 10 followers. Each one of my 10 followers have 10 followers. Each one of their 10 followers have 10 followers. And every follower can see the person they're following's posts. So the extent of the damage is almost perpetual.
Yes, there's actually two schools of thought. The one school of thought says that once you've published it out there, it's out there.
Yes.
One act of publication is sufficient,
right.
And you will then assess the reach of that publication. Obviously, if you have a close set, maybe 30 people, then only those 30 people got to know about it. Maybe you defamed one of your friends, and as a result of that, he then sued you. But obviously, if you have a public profile, then it becomes another story, because then that person takes the post and he then maybe republishes it on his post. So there's two schools of thought. The one school of thought says you only need to publish it once, and then the defamation is shown. But we've seen from British cases and Australian cases as well as American cases that now in cyberspace these additional acts of publication can actually perpetuate the damage and the injury caused to you.
Yeah.
So the issue of quantum is still a grey area.
Something that we still trying to work out.
But quantum has always been a grey area.
Would you say that cyber law, or should I say the acts that regulate cyber law, would you say that it has hampered or encouraged fair trade and commerce, especially in South Africa, amongst consumers?
Well, if you look at the UNICITRAL model law on e-commerce, which is the model law that basically gave life to our ECT Act.
Okay.
The ECT Act and the model law are facilitating acts.
Right.
If you look at the Act, it's very clear. It says to facilitate commerce, to facilitate e-commerce, to facilitate the recognition of written electronic data. So the cyber law can actually be used in a very useful way, and it has actually facilitated commerce. It has increased sales. People are using the internet. People are putting up websites to advertise their businesses. If you want to go on holiday now, you simply look for a location, you get the guest house. Whilst you're at it,
Make a payment online.
You make a payment online. So it has really, really made things very easy. But with this easy coming has also come easy crime. So, you know, easy come, but also easy, should I say, easy illegally used as well.
Yeah, absolutely. Well, talking about that, and this is something that a lot of people sitting at home would love to know. When you create a website, it's not so simple to go on to, I can't remember the name of that website where you can create your own website. Anyway,
domain?
No. It's a special website where you can log on.
Where you can create a website on their website.
Yes, you create a website and it's kind of hosted by them, and you can make it look really lovely. And and it's a website. Everybody will be able to see it. You'll send the link, and it will go out, and you know
it's out there.
And you've now got business. That form, and I don't want to kill it because we have to take another break here. But just think about this before we go to another ad break. Just creating a website, it's not really just that simple. There's a lot of regulations. There's a lot of compliance that you need to make sure of.
Definitely.
Right? I mean, talking about the contact us, the utilization of somebody else's information on that website. If you're going to utilize a sponsor or a client that you service to market yourself, the consent that's required. So think about that for a little bit. Whilst we're taking a little ad break, please remember the phone lines are open. The number to dial appears on your screen. It's 011 086 7700 01 or 2 or 3. 7700 01 or 2 or 3. Please call us and we'll take your call as soon as you come back from the ad break. Assalamu alaikum.
Adega, an upmarket Portuguese restaurant that offers a unique and memorable dining experience. The restaurant offers a warm ambiance and was voted Best of Johannesburg, Best Portuguese Restaurant for 7 years running. We aim to provide the best quality food and service. Make your booking today and enjoy fine dining at its best. Adega Restaurants, always open, always good.
Once in a lifetime prices at Lindsay Seca, Moore Street, Johannesburg. Get our cars at staff prices like the Polo 1.2 TSI Highline from 222,000, or the Jetta 1.4 TSI manual from 256,000, or the VW Tiguan 1.4 TSI Blue Motion from 299,000, or the VW Amarok Double Cab 4x4 from 470,000. Lindsay Seca, Moore Street.
Spice Mecca's newly packaged spices, categorized by spicy orange, exotic red, natural green, and magical purple. Use our blends and seasonings, masalas, herbs, or pure ground and whole spices to create yet another unforgettable taste experience. Choose your color, choose your number. We have your taste. So come on, do it the Spice Mecca way, the cook easy way.
Looking for the ultimate burger? Oh, yeah. To curb that craving 100% with 100% real ingredients, 100% freshness, 100% flavor, 100% choice, 100% quality, 100% purple. Unwrap a smile at Purple Burger.
Lifestyle Ceramics. Design your lifestyle.
Assalamu alaikum, welcome back to Legal Ease. We're talking cyber law with Sizwe Snail. Sizwe, we were just about to talk about websites.
Sure.
Not as easy as one might think, just getting on and creating a website or going to a company, some small sort of company who says, listen, we can do a website for you for 1,000 Rand. You know, not that easy. What's required? What more is required by a consumer wanting to start a business on the net?
Well, I can't give you exactly a complete blueprint as to what is required and what is not required, but there are certain acts that impact upon what you can do on a website and how the website needs to be presented. For instance, the ECT Act, if you're selling goods or services over the internet, there's a cooling off period there, there's certain rights that you have, there's a right to review, They must keep a record of the transaction. There's certain safety mechanisms they must use. If they're taking money from you using your credit card, the safety mechanism needs to be in terms of a certain technological standard.
Right.
So we've got certain rights and duties that emanate from the ECT Act in terms of the consumerism. In terms of the Companies Act, if you are a company, you will notice from the olden days on your letterhead, you must have your name there, then the registration of the company, telephone number. The new Companies Act similarly has a provision that says if you have any document in the public pertaining to your company, you must give out all this information. In terms of the Access to Information Act, you must also have a request form. If someone would like to request information from you, you might be keeping public information or private information. So there are numerous acts that impact on the type of business actually that you're doing. For instance, with attorneys, we got a circular recently from the Law Society that said if you're having an electronic email, are you required to put the names of the directors at the bottom? Or will a link to your website suffice where the directors are shown?
Yes.
You know, things like that.
Well, and talking about attorneys, there was a thing that came up when sort of internet usage and website usage really started to gather a lot of steam. And that was whether or not an attorney could give legal advice over the net. There was a restriction in terms of the Attorneys Act, if I can remember. Do you know anything too much about that?
Well, I'll put it to you like this. I don't think there's any express restriction on giving advice over the internet. I mean, it's like giving advice over the phone.
Yes.
However, I think one should be cautionate from a practitioner's point of view, not to give advice about something that you don't have enough information about.
Yes, of course.
In other words, if you do get an online request from a client asking you on a particular issue, rather go the safer route. Mail the client back, arrange a consultation, find out what the real issue is.
Obtain the full facts.
That's correct.
Yeah, very, very interesting. Sizwe, then going back, you were mentioning now about if you were selling something on the internet, cooling off periods. And as you were talking, I started remembering, of course, the Consumer Protection Act. We do a lot of work with regards to consumers in the Consumer Protection Act. CPA, again, is one of those acts that finds its home, or finds a home, rather, within the cyberspace. Things, for example, such as advertising on your website.
Yes. Well, you know, now that you use the word advertising, I want to use the word spam.
Okay.
Or unsolicited mail, as they call it.
Good.
In our ECT Act, we had a provision that says you need to opt out. In other words, we could send you as much spam as we like, but the moment you tell us, please don't send me, then we have to stop. In terms of the CPA, however, they've now brought in the opt-in provision, where you must actually have consented to be sent this mail.
Right.
Or if you are sent an unsolicited mail, there's even a duty upon you if the consumer says, where did you get my number? How did you get my number? You must then disclose as to what database you accessed.
Yes.
So there's a lot of restrictions now going on spam and trying to back down on spam. There's also organizations like WASPA, the Wireless Association, Service Providers Association.
Correct.
They also deal with complaints, but more with complaints pertaining to advertising and spam, where you're being sent SMSs, where you're being offered insurances, where you're being offered all sorts of...
Is this a sort of a watchdog type association or regulatory?
Yes, it's a self-regulatory organization to which all the telecoms communications companies in South Africa are members too.
Right, yeah.
It's self-regulatory. For you to become a member of that, you must agree to the code, the WASPA code. And then obviously if you're in breach of certain provisions like spam or the advertising codes,
these are obviously penalties,
or the auto-signing codes or whatever other, should I say, unbecoming conduct there is of these direct marketers. You then have to comply with those rulings. So there are definitely rules and regulations and watchdogs that are there to take care of these things.
What should we as consumers, as lay people, watch out for? I mean, one of the things I know, and I talk of a lot of to my clients, although I don't deal with electronic communications or anything, is blind clicking. You know, you just sort of click, I agree, I accept, I agree, I accept, I agree, I accept, and before you know it, somewhere down the line, you've signed your life away. You know, what are those? Are those some of the the things we should be cautioned about?
Actually, like I said to you earlier on, we do now in the ECT have this provision that says that where the law requires something to be in writing, you can do it by way of electronic data form.
Right.
There are two cases. One was in Natal, where an employee accepted employment by way of email and SMS.
Right.
And when he went then to go and report for work, the employer said, but you didn't accept the contract.
Right. Because in terms of the contract, it might have been had to have been in writing, for example.
It had to be in writing.
Right.
But because the ECT says where it is in data, it is also in writing. Judge Pillay, who's now with the UN Commission, she actually found that that particular employment contract was valid. Similar to that, we have another case that took place here in Johannesburg with the SABC,
right,
where one of the employees there cancelled his employment contract by way of SMS.
Resignation, for example.
And he resigned. And he then argued in court that he had not resigned because his employment contract said it must be in writing. The court then, in dismissing his case, said, but the ECT explicitly says that where something is in writing, it may be also in the form of a data message. So beware of the things that you agree upon on email, beware of the things that you agree upon on SMS. It's as good as
if you were doing it yourself in handwriting.
And there's also another provision in Section 11.3, which we call incorporation by reference.
Right.
Now, incorporation by reference basically says, if there's a hyperlink that is clearly visible, and there is something says, please check this link.
Right.
And you don't read that link, the fact that it's there, that it was accessible, it means that whatever terms and conditions are there, you are bound to them.
Yes, that's brilliant. You see, that's something that we really need to take cognizance of. One very important question, you mentioned it now when you're talking about spam mail. If a communication, an email, electronic mail, is sent through to you, for instance, but it ends up in your junk mail folder, it ends up in your spam mail folder, is it considered to have been received?
That's actually very interesting. The ECT says an email will be deemed to have been received if the recipient thereof can access the email and it is readily accessible for subsequent use. In other words, the fact that it entered your information system was accessible to you and accessible for subsequent use means that, yes, you have received it.
Even if it's in the spam mail and you may not have seen it at the time, or you might have only seen it a week or two or a month later.
Yes, what we have now is, you will recall from your law of contract, we have all those different theories, the declaration theory, the information theory, and the expedition theory in the true postal contract. We now have an amended reception theory.
Okay.
By way of the law that says, well, if you have received it in your information system and it is readily accessible to you, you are deemed to have received it. So that is some of the things that are changed in the law which even practitioners are not cognizant about. So that's quite tricky.
But is there not an onus then on the sender to ensure that whatever they are sending, ultimately, in accordance with the ECT, to ensure that what they are sending is not deemed to be unsolicited mail or bulk or spam? Is there an onus there in terms of the Act?
Well, as we said, in terms of the Act, you were allowed to basically spam people and then not spam them if they say, don't spam us. But now in terms of the CPA, like I said, it has changed that. There's no magic wand or magic software that can control junk mail. As a matter of fact, when you sent me the mail to the show, it was in the junk mail folder as well. So, you know,
is there a setting on your incoming server that regulates it?
It can either be on your Outlook if you're using things like Outlook or Pegasus Mail, whatever mail server that you're using. It picks up certain strands and emails, certain words. You may have blocked a particular email by mistake. You may have put it in a junk folder. one particular email may have been sent to you more than 4 times, and if that happens, some software look at that as a suspicious email and they'll place it in the junk file folder. So I always tell my clients, regularly check your junk file folder. Junk mail folder.
Junk mail folder.
Yeah,
yes.
Your junk mail folder is your folder.
Sometimes it is fail and it is quite moldy, so don't worry. I'm sure you were thinking about that. Yeah, I hear what you're saying. Taking from the common law, when I send a letter of demand, my letter of demand says that, or in a contract, if the notice provision in a contract or an agreement ultimately says this document is, the notice will be considered to have been received by you within 7 days from transmission or proof of transmission by the sender. So I'm now sending you a letter of demand or breach or something, or some sort of a notice. In terms of the contract, the minute it's posted by the post, by registered mail, the minute it's sent out, and I have the registered mail slip, which is something that really has found its place in our law, in our common law, it's considered to have been received with you within 7 days. Is there similar provision in the Act? Taking the spam mail issue into place, I've now sent a mail. I don't have a proof that it's been sent because you've never clicked read receipt, and you've not allowed a delivery report. And if it goes into a spam, more often that it won't get delivered. How do I prove now that I've sent it to you? 1, or 2, is the fact that I've sent it automatic, and I say I've sent it, and I show that there's an outgoing or a mail showing sent in my mailbox server is sufficient for purposes of it having been received by you.
You see, that's the beauty with the ECT Act. It brought in a concept from the unilateral model law called party autonomy.
Right.
The parties can agree to the specific terms of the contract and to specific elements of the contract, specific elements of the notice.
Right.
For instance, in the olden days, like you correctly said, you could specifically agree that if I need to send you a notice, if it's done by registered mail and I show you the proof, then it is proof that I've sent it to you. Similar in the ECT,
but let's assume there's no provision. Let's assume there's no agreement. Again, take an employee who wants to resign. Remember, constructive dismissal, the starting phase of any constructive dismissal referral to the CCMA or to any bargaining council is that the employee has terminated employment.
Right.
So if she sends an email or a resignation letter via email, which I don't get, has she resigned?
Well, you don't have to get it, as I said. The fact that it's on your mail server.
I deny that it's on my mail server.
Well, that was the facts in that JAFTA case, the one in Natal, where the employer specifically said, but we didn't receive it. We didn't have sight of it, you know. But if you then go and you can prove this very easily, it's very easy to track an email as to where it has gone, how it has bounced off, and what service. There's software that can do that. Once you have shown that it did actually enter that information system of the recipient, and it wasn't a format that is readable. In other words, if you send a document to someone with a format that only you have the decoder for, then in terms of that provision, it is not subsequently usable.
Or readily available.
You see. But if it's in a PDF or it's in a Word document, in a format that is acceptable to you that you can use, then the moment it enters your mail server and it is accessible to you and it is there, you are deemed to have received it.
What is the way forward for cyber law in South Africa? I mean, what is there yet to do? You know, are we really in the race against sort of the likes of the information giants or the IT giants such as India and China? You know, is there something that we can aspire to, or are we comfortable where we are?
I think in terms of recognizing and facilitating e-commerce and that stuff, I think our law is relatively well developed in terms of protecting consumers and things. I think our law has actually encompassed most of the good things that is being done internationally in terms of best practice. The areas maybe where our law needs to maybe be reviewed a bit, and that is because of the rapid way in which the criminals change their ways of doing things, is our cybercrime law. There are whispers that we are currently reviewing our cybercrime law here in South Africa to be in line with what we call the Budapest Convention. The Budapest Convention is the cybercrime convention by Council of Europe. It is a European document, but a lot of countries that are not members of Council of Europe have actually signed it. South Africa has also signed it as well. And that is being used now as our international best practice to draft our laws.
Okay.
So in terms of catching up with criminal activity, I think South Africa does need to, review its laws. But that is happening all over. In America just now, they've reviewed their cybersecurity policy, in Germany as well. So it's an ongoing thing. As much as the technology evolves, the law needs to evolve as well.
Sure. Just as you're sitting and talking about cybercrime, I'm thinking about cyber terrorism and how you could literally get into somebody's database or server and wipe them off the face of the earth. And this is where I'm sure those enforcers of the cybercrime regulations and things of that nature, those enforcers really need to be so well trained in the cyberspace, really to be able to guard against these things, putting up of firewalls, defending against worms that come into through email and through internet and things of that nature. Are we there?
We are. Well, in South Africa, for instance, we now have a CERT, that is a computer emergency response team, or a center even, where there are people that are basically monitoring the activity on our internet, certain cyber threats, cyber terrorism threats as well. There are various initiatives as well by various international organizations. As I mentioned to you as well, the AU, they've now come up with an African cybersecurity convention that places certain minimum duties on certain states to do certain things to not just protect themselves but also to protect their citizens. The issue of cyber terrorism is a reality. I mean, you heard what happened about Germany spying. America spying on Germany,
yes,
and China also spying on other states.
Yes, and then spying, and I think it was the UK spying on South Africa during the summit, if I'm not mistaken.
That's correct.
Things of that nature.
It's a reality. It's happening. Agencies are now finding ways to outdo each other in how to spy and not get caught.
Yeah.
So it's definitely a topic that's there.
In a nutshell, and in closing on this very, very informative topic, Sizwe, a lot of people take the approach of, I'm staying away from social media, I'm staying off the internet, I prefer to do things by a pigeon as opposed to cyber. Is that really the approach, or is it just a situation of be cautious, be alert, and be educated?
I think the e-commerce generation is a generation that we're in now already. It's a reality. We use computers, we use our phones, we use our iPads. We are users of e-commerce tools.
Right.
So for one to simply say, and that, no, I'm not interested in a computer, I'm not interested in that particular service, I think being not interested exposes you to more danger than being interested.
Yeah, absolutely.
I follow the school of thought of educating.
Yes.
And education not just amongst adults, but education amongst children as well. That is how you can deal with instances of cyberbullying where your child is being bullied at school or by way of social media.
Yeah. Well, if you do want to know and if you do want to be educated, I would advise very strongly Google, that's on the internet, Google snailattorneys.com. You'll see also Mr. Snail's details at the bottom of the screen. Call him, email him, get involved, see if you can join the conference that he puts out, or some of the publications. Buy the textbook, and I think all of us really need to make an asserted effort to educate ourselves on this thing called cyber law. So we know what to do when the spies come, when the worms come, and when the bugs come, and tell them that we have a snail on our side. So thank you very, very much, Mr. Snail, for joining us this evening.
Thank
you for educating us and educating the viewers. I think it's really been an informative show. Inshallah, viewers, stay tuned. We are winding down to the end of the season. Next year, we have a whole host of very, very exciting topics that we're going to be talking about. A lot of off-site shootings, out-of-studio shootings. We're going to be bringing you a lot of information, a lot of exciting and fun topics that we're going to be talking about, because the aim of the show is to really give to you, the viewer, an easy way to understand what bugs us on a daily basis, and that is essentially the law. So Jazakallah so much for staying with us. Jummah Mubarak, Assalamu alaikum. This is Legal Ease.